so much. I'm so grateful to Angela and Helen for inviting me to share this work. I'm really excited to share it with all of you. So today, as Angela said, I'm going to talk to you about one of the most important legal cases that really most people have never heard of, Somerset v. Stewart. So in the case of Somerset v. Stewart, William Murray, Baron and later Earl of Mansfield and Chief Justice of the Court of the King's Bench, ruled on the 22nd of June, 1772, that it was unlawful for Charles Stewart, who was a British Massachusetts-based customs official, to transport James Somerset, an African he had bought in Virginia, forcibly out of England. So when the verdict was announced, it sent political and legal shockwaves through Britain and its American colonies. And although the decision was technically a narrow one, it was popularly taken to mean that slavery was illegal in England. So let's begin by introducing the participants in the case. Lord Chief Justice William Mansfield, at the time of the case, William Murray, who was the first Earl of Mansfield, was living in Kenwood House on the edge of Hampstead Heath with his wife and two nieces, Lady Elizabeth Murray and Dido Bell, the mixed heritage daughter of his nephew, Captain John Lindsay. So the picture that we see here is Kenwood House, and it's all very familiar to you. The next person we're going to talk about is Dido Bell, and we've mentioned Dido here before, and you'll all be familiar with this picture, this painting, which is in Scone Castle. And the next person we're going to talk about is Captain John Lindsay. So this is the portrait bust, which is in Kenwood, and was, of course, helped to purchase for Kenwood by the Friends. So again, we're very grateful. And we have a cameo medallion here, portrait medallion of Sir John Lindsay, which is also in Kenwood House. So we're going to talk a little bit about John Lindsay first. So he was born in 1737. He was the youngest son of Sir Alexander Lindsay and his wife Amelia Murray, who was the daughter of the fifth Viscount Stormont, sister of William Murray, who was the first Earl of Mansfield, who owned Kenwood, who is one of the people that we're talking about today. So John joined the Royal Navy as a midshipman during the 7 Years' War. And in 1757, he was promoted to the rank of captain and given the command of a 28-gun frigate called the HMS Trent. For the next decade or so, he was principally stationed in North America and the Caribbean, protecting British colonial interests. So it was during this time that Lindsay fathered 5 illegitimate children, 4 of whom were of mixed heritage, including his daughter, Dido Elizabeth Bell, whose mother was an enslaved African girl called Maria. And in 1766, Sir John brought Dido to England and placed Dido in the care of his uncle, William Murray. So the portrait medallion here is one by the celebrated Scottish gem engraver and modeler James Tassie. It was made in 1791, and it's based on the marble bust by the sculptor Michael Foy in 1776, which we've just seen. And again, both of which are in the collection at Kenwood, again, thanks to the generosity of friends. So here we have the portrait of William Murray. So as Lord Chief Justice for over 30 years, from 1756 to 1788, Mansfield was the most powerful jurist in Britain and ruled on many famous cases and oversaw significant reforms to the legal system in England, improving access to legal aid, modernizing commercial, merchant, and common law. So the next person that we're going to talk about is Charles Stewart. So this is a painting of Charles Stewart, which is in the Colonial Williamsburg collection in the United States. Stewart was born in Scotland around 1725 and moved to Norfolk, Virginia in 1741 to work as a storekeeper for a tobacco merchant. The business prospered and he eventually set up his own mercantile establishment in Norfolk. And then in 1749, when he was 24 years old, Stewart purchased Somerset, who was 8 years old at the time. Stewart's fortunes changed in 1762 when he prevented an international incident by defending a party of Spanish naval officers from a Norfolk, Virginia mob as sort of a reward for his actions in handling what's called the Don Pedro Bermudez affair. King George III named him Receiver General of His Majesty's Customs in North America. And by the time Stewart sailed for Britain in 1769, he had risen to be the Paymaster General of the American Customs Board and had moved to Boston, Massachusetts. It was quite a meteoric rise from a tobacco merchant seller to the position he eventually obtained. So, of course, the person this is all really about is James Somerset. Of course, we don't know what he looked like. We don't have any images of him or any descriptions that I'm aware of. So I'm going to use the beautiful illustration that was done by Sam Young for our members magazine, and for which you'll be familiar and see here. So James Somerset was born around 1741 in West Africa. At the age of around 8 years old, he was captured and sold to European slavers who transported him to the British colony of Virginia. On the 1st of August, 1749, aged 8, Somerset was sold to the Scottish merchant Charles Stewart in Norfolk, Virginia. And in 1764, Somerset was taken to Boston, where Stewart had been appointed Receiver General of Customs. So despite the importance of the case, very little is actually known about James Somerset. His name, Somerset, for example, was most likely given to him by the slave traders when he was transported to America in 1749, or in Jamaica, where it's possible that Somerset first disembarked. Scholars have also been unable to identify the ship which transported Somerset to North America, as all known copies of the Virginia Gazette from that period were burned in a fire in 1851. One possibility that's been considered is the sloop called Diamond, which regularly transported enslaved people for sale through Charles Stewart's firm and made frequent voyages in the correct period. So this is not the sloop Diamond. This is a painting of another ship from about the same period, but should give you a little bit of a sense of what that boat might have looked like. And of course, this is the famous stowage of the British slave ship Brooke, which is later from 1788. But I think everybody's have seen this image before, and sort of the horrors of that transportation. So it's hard to imagine what an 8-year-old child would have experienced on that voyage, and what would have sort of happened. So just going back to James Somerset. So Somerset was one of several enslaved people in Charles Stewart's ownership, including, and this is a quote, the Negroes George, Lawson, Somerset, Nanny, Quashabo, and Amaker. So the latter two names were women with African names, and the second of whom records indicate bore multiple children. It's unclear who fathered those children, whether, but of course, the horrors of slavery didn't end with the voyage. But between Stewart's arrival in Boston and departure for London, he appears to have sold or leased all of the enslaved people in his charge, except for Somerset. So in November 1769, when Stewart relocated to England following the death of his sister's husband, he took Somerset with him. And whilst in London, it seems that they resided in Baldwin Gardens in Holborn. And so this is a map of Baldwin Gardens from 1746. Holborn Gardens was bombed quite a bit during the Second World War, and it's not clear whether any of the buildings that related to Somerset's period there have survived. So now we're just gonna, so those are the individuals at the center of the court case, and let's move on now to the background of the case itself. So during the period after when Somerset moved to England with Stewart in November 1769, Somerset was frequently sent on errands by Stewart, which took him not only around London, but also into the English countryside. And it's most likely that at this time, Somerset came into contact with a number of free Blacks and white abolitionists. It's difficult to estimate the number of Black people living in Britain at the time of the Somerset case. During the 18th century, the total Black population of England became the subject of wide and widely varying speculation. An angry and racist letter in the Gentleman's Magazine estimates the number at 20,000 in London and growing. There we go. This is a little clip of that letter. So the letter says the practice of importing Negro servants into these kingdoms is said to be already a grievance that requires a remedy, and yet is every day encouraged, insomuch as the number in this metropolis only is supposed to be near 20,000. So that is one of the estimates, or one of the bits of evidence that we have for understanding the number of Black people in Britain at this time. So 1 year later, though, the Morning Chronicle, which is another publication, raised that number to 30,000, whereas during the Somerset trial, Mansfield discussed an estimate of around 15,000. Granville Sharp, who we'll come to in a moment, himself placed the number at 20,000 for all of England. And while the best contemporary sources are really obviously very inexact, in view of Sharp's association with the Black community and through his activism, his estimate seems the most one that's most reliable. So England's Black communities lived predominantly in London at this time, but there were also Black people living in other parts of England, mostly in Bristol and Liverpool, as well as some in the wider countryside. We know, for example, that during the period where we have the Black Caribbean prisoners of war at Portchester Castle, during the Napoleonic period, which is obviously a bit later than this, many of them stayed in the area and moved around. So there's a large number, and in these and as you can see, the sort of the Black people in England in the 18th century originated from many countries and backgrounds, for whom and these communities provided both really important social links and actually an informal political network as well. So in this clipping from the London Chronicle from 1764, this is one of the bits of evidence that we have. It says that of the sundry fashionable routs or clubs that are held in town, that of the Blacks or Negro servants is not the least. Men and women supped, drank, and entertained themselves with dancing and music at a public house in Fleet Street. All the performers were Black. So this is something that was notable and noted in the London Chronicle, and you can see that these sorts of activities are happening, and there are these groups of people who are coming together, and that means that they were able to communicate with each other and plan these sorts of events, and that indicates a level of networking and networks that are really important. So academics like Keith Albert Sandalford have argued that in the face of growing hostility from their English hosts, the Black community was forced to pool its own resources and devise strategies for the group's protection. So contemporary sources all really concur in their testimony that the community was a tight-knit, cohesive, and supporting of its members in a variety of ways. And it's likely that through these networks, Somerset came into contact with Thomas Walkin, Elizabeth Cade, and John Marlowe, who became his godparents when he was baptized in August of 1771 in the Church of St. Andrew in Holborn. And here's a picture of the Church of St. Andrew. And as you can see from the top, this is an entry from the baptism register. James Somerset, an adult Negro about 30 years old, Baldwin Gardens. So that's where we get the idea that that's where he was residing, where that comes from. So moving on to the court case. So a writ of habeas corpus is the thing that lies really at the heart of this case and indicates that Somerset began to be known formally by James at some point. So his Christian name, James, was most likely added and perhaps even chosen by Somerset in relation to his baptism. And now we get into sort of a bit of the weeds of what's happening legally. So in 1729, there was a decision called the York Talbot opinion, which held that baptism did not emancipate slaves, and that slaves or enslaved people brought to England from the colonies who were then converted to Christianity could be returned to service. And many people were under the misapprehension that baptism was an effective mechanism to manumit enslaved people in England. Perhaps because baptism was often associated with manumission, on the 1st of October, 1771, Somerset left Stewart and refused to return to a state of permanent servitude. Stewart was very angry and put up notices, but Somerset did not return. Somerset managed to live in freedom for almost 2 months, but on 26th of November, 1771, he was kidnapped by slave hunters and on Stewart's orders delivered to Captain John Knowles, who was the captain of the ship, the Anne and Mary, where Somerset was confined in irons and awaiting transportation to Jamaica, where he was due to be sold again, but this time to a plantation for labor. So now we come on to the writ of habeas corpus. So first kidnapped and then facing being sent to Jamaica as a plantation slave, the stakes for Somerset could really hardly have been higher. On the 3rd of December, Somerset's godparents made an application before the Court of King's Bench for a writ of habeas corpus, and Granville Sharp was enlisted to support Somerset's case. Now, Sharp was an inveterate opponent to the institution of slavery and thought it was antithetical to the British Constitution and English common law. 6 days later, Captain John Knowles produced Somerset before the Court of the King's Bench, which had to then determine whether his imprisonment was lawful. So the King's Bench was the oldest and highest common law court in England. Its name is derived from the period when the king himself sat in judgment in the court. And in 1771, it consisted of a chief justice and 4 associate justices. And the chief justice of the King's Bench was Lord Mansfield, and he ordered a hearing for 21 January, and in the meantime set Somerset free on recognizance. So, who is Lord Mansfield? So we've gone over him a little bit, but just to give you this background refresher. So Lord Mansfield was a former Attorney General. He was a cabinet minister and a firm upholder of the powers of Parliament over the king and the colonies. So prior to the Somerset case and subsequent case concerning the Zong massacre, which many of you may have heard of, Mansfield was known for his rationalization of British law to facilitate commerce. So Granville Sharp and Mansfield seem to have been known to one another. In Sharp's previous cases involving enslaved people brought to England, Lord Mansfield had persuaded the owner of the enslaved people to free the enslaved person, thus enabling Mansfield to avoid issuing a legal decision. And in 1771, Mansfield had told a lawyer, quote, "Perhaps it's better that it," meaning the legality of slavery, "should never be discussed or settled. I don't know what the consequences may be if the masters were to lose their property by accidentally bringing their slaves to England." So Mansfield, at the time of the Somerset case, tried various ways to avoid taking the case entirely. Initially, he tried to persuade Stewart to free Somerset, as had happened on several recent similar occasions, and Stewart refused. And as sort of last resort, Mansfield tried to persuade one of Somerset's godparents, Elizabeth Cade, to purchase him from Stewart and set him free, but she declined on principle. And she wrote that by purchasing Somerset, it would acknowledge that Stewart, quote, "had a right to assault and imprison a poor innocent man in this kingdom." So, resigned to the situation and aware of the potential of the case to cause substantial disruption, Mansfield sort of declared as part of his rulings, if the parties will have justice, fiat justitia ruat coelum, which is "let justice be done though the heavens fall," and of course a very famous quote. In late May, which is the month before the judgment was issued, a London newspaper speculated that on the potential consequences of the pending ruling, quote, "The West India merchants have, we hear, obtained a promise from Mr. Stewart not to accommodate the Somerset the slave's cause, but to have the point solemnly determined, since if the laws of England do not confirm the colony laws with respect to property and slaves, no man of common sense will, for future, lay out his money in so precarious a commodity, the consequences of which will be inevitable ruin to the British West Indies." So there we can see the sort of the urgency and importance that the West Indian planters in particular are placing on the outcome going in their way. However, and this is really important, the importance of enslaved labor for the production and supply of commodities in Britain was by the late 18th century dwindling, but the transatlantic slave economy was still a very important part of Britain's economic portfolio. The opportunities provided by imperial expansion into South Asia and Southeast Asia was beginning to outweigh the economic potential or economic importance of enslavement and the colonies, and so this was becoming less important overall. But of course, for those merchants, or for those people who had really most of the investments in enslavement or in the commodities that were produced by enslavement, the idea that enslavement could end was very difficult for them to see how they would and not end up in financial ruin. So Somerset's case, for all of these reasons, was seen as a test of the legality of slavery in England, and its proceedings were followed very closely by the West Indian planters, of course, and abolitionists as well. So earlier in June 1772, before the ruling, Charles Stewart wrote to his friend James Murray, no relation, the West Indian planters and merchants have taken it off my hands, and I shall be entirely directed by them in the further defense of it. So he had sort of been sidelined in this whole process, and the West Indian planters bankrolled the case and, of course, refused all offers to settle out of court in the hopes of finally resolving the question of slavery in England in their favor. But while the planters campaigned for a decision that would recognize colonial laws relating to slavery and enforce them in England, Somerset's attorneys and legal support team, including Granville Sharp, advocated a ruling which would forbid slavery in England. Somerset's case was pleaded by William Davy, John Glynn, Francis Hargrave, James Mansfield, and John Alleyne. And the opposing opposition was argued by John Dunning and William Molas, whose services, as I mentioned, were funded by the West India planters, who were really just as interested as Granville Sharp was in using the Somerset case as a test case. So Sharp also seized the occasion as an opportunity to deploy arguments he developed in something he had written called A Representation of the Injustice and Dangerous Tendency of Tolerating Slavery in England. Worried that his presence might adversely affect the trial's outcome because he had sort of gained a certain amount of notoriety at this point, Sharp passed his notes to Francis Hargrave, who was a leading lawyer on the case and basically kept a low profile as it made its way through the court. So when Somerset's case finally came to trial in June of 1772, the lawyers for Captain Knowles contended that slavery was the 18th century successor of villanage and therefore part of a continuous legal practice. Villanage was a medieval feudal concept that created a bond service contract between a feudal villein who held land and the lord who owned it and who could be required to provide services to the lord without payment. So Somerset's lawyers defined villanage as a slavery in blood and family, one uninterruptedly transmitted through a long line of ancestors, and argued that English ancestry was a requirement of villanage. Therefore, it could not be conferred upon a person whose birthplace and people, such as James Somerset, were not English. They argued that villanage had expired anyway, and that there was no positive law relating to slavery in England, and that the law of Virginia, under which the contract or Somerset's enslavement was made, was not applicable in England. Furthermore, Somerset could not be accused of breach of contract because the basic requirement for any contract is that the parties be free to enter into the contract, and that hadn't been met, with Somerset having been, kidnapped and didn't have any choice in the matter. So at this point, lots of people have asked me about, and where historians often get asked about Dido Bell and what influence she would have had on Mansfield and the ruling in Somerset v. Stewart. The short answer is that Mansfield was entirely focused on the law and the primacy of Parliament, and you can't really draw, in my opinion, a line connecting Dido's presence in his household and the decision in the Somerset case. I mean, clearly his life was affected by having Dido in the house, and of course she didn't participate in the household in the same way as his niece Elizabeth Murray did. However, we do know that he held Dido in high esteem. She often played an important role in explaining the care of his prized cattle to guests Kenwood, and I think she also helped him with his correspondence and so forth. And of course, we don't know, and I'm not aware of any evidence from his journals or any writing where he indicates that having Dido in the house influenced his legal decisions. And of course, that would be pretty extraordinary. But I think what we can say is that it's hard to see how Mansfield, through his relationship with Dido, could have held the kind of racist views that persisted at the time, and that chattel slavery being based on the practice of dehumanization of people from Africa, and the perspective that didn't regard them as people. It's really hard to see how Mansfield could have shared those views. And so now I guess this brings us to the ruling. So Mansfield's judgment began. The only question before us is whether the cause on the return is sufficient. If it is, the Negro must be remanded. If it is not, then he must be discharged. So this is all about the writ of habeas corpus. And a writ of habeas corpus, which is Latin for you have the body, was issued by a court of justice to someone holding another person in custody. The writ directs the detainer to bring their prisoner to a court at a specific time for a particular reason. And although there were many versions of the writ, the one issued in Somerset's case is best known as a legal instrument by which to correct violations of person's liberty by releasing an individual from unlawful detention. So as habeas corpus determines whether a person has been afforded due process and not whether he or she is guilty, Somerset's case at the King's Bench was argued against Captain Knowles, who was the one who was accused of unlawfully detaining Somerset. So the legal question at stake in the case was not whether slavery was legal or illegal, but whether Captain Knowles, or Stewart for that matter, had a legal right to detain Somerset. And the judgment continued. Accordingly, the return states that the slave departed and refused to serve, whereupon he was kept to be sold abroad. So high an act of dominion must be recognized by the law of the country where it is issued. The power of the master over his slave has been extremely different in different countries. The state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political, but only by positive law, which preserves its force long after the reasons, occasion, and time itself from whence it was created is erased from memory. It is so odious that nothing can be suffered to support it but positive law. Whatever inconveniences therefore may follow from this decision, I cannot say this case is allowed or approved by the law of England, and therefore the black must be discharged. So the court narrowly held then that a master could not see an enslaved person in England and detain him in preparation for sending him out of the realm to be sold, and that habeas corpus was a right available to enslaved people to forestall such seizure, deportation, and sale, because they were not chattel or mere property, they were servants, and thus persons invested with certain but definitely limited constitutional protections. So where Mansfield's judgment was rather bold was that he stated that there was no positive law establishing slavery in England. Indeed, earlier in Mansfield's ruling, he states, we cannot in any of these points direct the law must rule us. And I guess although in some ways Mansfield took great care to phrase his holding in such a way that it could not be used for a broader precedent in determining the legal status of slaves or their rights, it was widely perceived very differently on both sides of the Atlantic. Many, including many enslaved people, understood Somerset to have effectively abolished slavery in England. Somerset himself, for example, believed so. And London's Black community were politically very aware and involved in the abolitionist movement and followed the Somerset case very carefully. Representatives were sent to follow the hearings and then celebrated when the judgment was given. There we go. The image is a bit grainy. But on the 27th of June, 1772, the Public Advertiser reported, on Monday, nearly 200 blacks with their ladies had an entertainment at the public house in Westminster to celebrate the triumph which their brother Somerset had obtained over Mr. Stewart, his master. Lord Mansfield's health was echoed round the room, and the evening was concluded with a ball. The tickets for admittance to this black assembly were 5 shillings each, which is about 40 pounds in today's money. So this is quite a big deal, very expensive, but clearly a really, really important celebration. People came together, and it was very clear that Mansfield was seen as having done a good thing. And of course, this was all about, and Somerset was the heart of the celebration. So Somerset himself, following the ruling, have appeared to have adopted the broader interpretation and wrote to at least one enslaved person, encouraging him to desert his master. So in a letter dated the 10th of July, 1772, a friend of Charles Stewart called John Riddle wrote to Stewart, quote, I am disappointed by Mr. Dublin, who has run away. This one I've typed out, so you can probably read it. He told the servants that he had received a letter from his uncle Somerset, acquainting him that Lord Mansfield had given them their freedoms, and he was determined to leave me so soon as I returned from London, which he did without even speaking to me. I don't find that he has gone with anything of mine, only carried off all his clothes, which I don't know whether he had any right to do so. I believe I shall not give myself any trouble to look after the ungrateful villain. So Somerset's letter to his nephew Dublin, whether relation was by blood or merely symbolic, we don't know, provides a glimpse into the Black community of 18th century Britain and hinting at its tenacious coherence in the face of opposition. It also suggests the process by which Blacks in England made Lord Mansfield's decision known amongst themselves and how they acted with their feet on the understanding of its jurisprudential significance. So, of course, though, this letter is the last sort of hard evidence that we have of James Somerset, and that is where I'm going to end the lecture. There's a little bit more to say, but I think it will probably come up in the Q&A. Thank you all very much for your time and listening to me. I'm going to stop sharing my screen.